Hey, what's up? Doug from Salt Lake. All right, we got a court date coming up in 2 weeks. I got another couple of motions. I wanted to go over a couple of things with you that I have discovered. Once again, everything that I say is my opinion. It's not legal advice. It's not advice. It's just what I'm doing in my case. So, talking and reading, lots of reading going on, trying to get past and survive a motion to dismiss. So the first thing we're going to talk about is Trinzi versus Pagliaro. Okay? So it says in the case, an attorney cannot admit evidence into the court. She's either an attorney or a witness. Statements of counsel in brief or an argument are not sufficient for a motion to dismiss or for summary judgment. And the defendant's motion to dismiss for failure to state a claim unsupported by affidavits or depositions is incomplete because it requests the court to consider facts outside the record which have not been presented in the form required by Rule 12b-6. Well, that's your motion to dismiss right there, 12b-6. They always say that you failed to state a claim upon which relief can be granted. Okay? Statements of counsel in their briefs and arguments, while enlightening to the court, are not sufficient for purposes of granting a motion to dismiss. Okay? So, that would be an objection. Statements of counsel are not sufficient for a motion to dismiss. Okay? And I wrote it all down. And something else I found out is that is considered arguing outside the facts that are in evidence. And the only facts before this court are my affidavits and my exhibits. Okay? Where there are no depositions, okay, when you depose somebody, admissions, or affidavits, the court has no facts to rely on for summary determination. Okay? This is a good case. Okay? This is a case for us. So, my first response would be as soon as that attorney that is a third party starts trying to add something to the record, you need to immediately object and ask the court, hey, listen, I object. I want this person sworn in. Okay? And because I want them sworn in, I'm going to follow procedure. And what I'm going to do is I'm going to add a writ for affidavit of commercial liability. Okay? So files this writ. Affidavit notices the court this man objects to counsel adding to the record anything that is not in affidavit form. Sworn to under penalty of perjury and with full commercial liability. Okay? And then I quoted the case. Where there are no depositions, admissions, or affidavits, the court has no facts to rely on. An attorney for the defendant cannot admit evidence into the court. He is either an attorney or a witness. Trinzi versus Pagliaro. Okay? So, Mr. Mooney moves the court to rule on his writ before the motion to dismiss hearing, scheduled October 30th, and demands that counsel not be permitted to add to the record any third-party hearsay. Plaintiff will allow the affidavit attached. So I wrote up an affidavit, and I want her, him, whoever, to sign this. And I'll let you read it. Okay? Very simple. Okay? Which they're not going to do. So I'm going to object every time that person opens their frickin' mouth. So I got another motion from these knuckleheads that said that they're going back to the motion to dismiss and back to the contract, and they said there is no contractual obligation because there was no offer and there was no acceptance. Okay? Well, I disagree. So this is off of my complaint. This is my declaration by affidavit. And you'll see that I created and recorded a notice of acceptance. Okay? Now, let's go through these real quick because this is where it started. I made the phone call. I asked somebody, and if you watched my videos, you'll know back a year ago, okay, I asked somebody to put their name on a document and sign it. And what does that say right there? That says Alyssa Barlow. Okay? June 13th. They say this is the obligor. Okay? It says I owe him $25,000. And look what she did, man. She put her name on there and signed it. Okay? Now look at the date, June 13th. Correct? Okay. So, June 13th, July 8th. I sent a confirmation letter to Alyssa. I am in receipt of your past due letter. June 13th, right? And I said, hey, I sent you all these documents and you didn't respond. So here's the first one, right? I also sent one to the director and to Lisa Stockdale, the manager. Okay? And if you look at it, here's the copies of one for each, blah, 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 blah. Alyssa got one, Ann got one, Lisa got one. Now, 2 weeks later, we started using our notarial protest. Okay? And here is my notice of acceptance. So these knuckleheads are trying to come into this court and add stuff to the record that is fraudulent, that is a freaking lie, okay? Because this is a letter of this is an offer. This is a letter offering me to do business with them, okay? And this one is a letter of acceptance. So don't let these idiots come into the courtroom and buddy up with the judge unless they are sworn in and have signed a affidavit stating that everything that they're saying is true and correct. Because you know what? There is no law about lying. Now, there is a law about perjuring yourself, and that's when you're under oath, and you must bring it up. I'm going to bring it up. I'm going to bring it up. So let's go back to the motion to dismiss. The Supreme Court recited the standard for surviving a motion to dismiss. It says, when considering a motion to dismiss brought under 12b-6, the allegations of the complaint should be construed favorably to the pleader. That would be me. Schuer versus Rhodes. The court must inquire, however, whether the complaint meets the plausibility standard described by the United States Supreme Court. An example would be whether it adequately states a claim and provides a showing of any set of facts consistent with the allegations in the complaint. Okay? And there's Bell Atlanta Corp versus Twombly. Okay? To survive a motion to dismiss, a complaint must contain sufficient factual matter accepted as true to state a claim for relief that is plausible on its face. Okay? And then it's Ashcroft versus, I think that's Iqbal. Lawyers frequently refer to this as the Iqbal standard. Plaintiff's complaint contains a plausible claim for breach of contract, a plausible claim for relief, and alleges breach of the covenant of good faith and fair dealing. Remember in my complaint, I said I come to this court with clean hands and in good faith. Okay? Now, the other thing that I've figured out is, well, let me read this first. We have a case, this is Morris versus National Cash Register. It says the representative of the plaintiff is likely to be the only individual now or in the future who is willing and able to place a sworn affidavit affirming the herein disclosed facts under penalties of perjury into the record of this case, and as such, in absence of sworn counter affidavits signed under the penalties of perjury, blah, 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 the plaintiff should be the only prevailing party. Now, what does that say? That says uncontested allegations in an affidavit must be accepted as true. Okay? Group versus Finletter. Allegations in affidavit in support of a motion must be considered as true in absence of a counter affidavit, right? So, Exhibit 1, bill in equity, okay? And you did not rebut this, and there's nothing to argue about because this has already been decided. And just so that I can rebut all of their presumptions in their motions, we're going to go over a couple of things, and you guys, we'll see if this works. We'll see what happens in a couple of weeks. But I touched on a few things, and just so you guys know, these de facto corporations do not have sovereignty, and they do not have immunity, and they cannot just run around and beat the shit out of us and use us for the surety for their bonds, okay? Especially when we bring it up. So, plaintiff representative incorporates all facts in all documents entered as though fully set forth herein. I got that off of a federal lawsuit. First, the last motion I entered was about offer and acceptance, okay? As you can see from Exhibit ASB 1, which is Alyssa S. Barlow 1, that I filed, that letter is clearly an offer. And Exhibit A in my process is clearly acceptance. It's called a notice of acceptance. You can't really get any clearer than that. I have a white notebook. There's several other offers and acceptances. We've been through all those before. The language seen in the certificate of non-response by the notary is not debatable. Okay? There is no dispute. There is no debate. Okay? This is about an administrative process. It's not about immunity, sovereignty, or whatever. Okay? It's about the contract. As to sovereignty, okay? The courts and the judge and the AG's office and the state of Utah and ORS and child support, they're all going to scream and yell and say, we're sovereign. Well, as to sovereignty, Bond versus United States, volume 529, U.S. reports, page 334, in the year 2000 said, the Supreme Court held that the American people are in fact sovereign and not the states or the government. The court went on to define that local, state, and federal law enforcement officials were actually committing unlawful actions against the sovereign people by the enforcement of their laws, their private corporate policies, and are personally liable for their actions. The sovereignty of the state resides in the people, and the sovereignty of the United States resides in the people, and Congress cannot invoke the sovereignty of the people to override their will. Perry versus United States. The government is but trustees, acting under derived authority and have no power to delegate what is not delegated to them. But the people, as the original fountain, might take away what they have delegated and entrust it to whom they please. The sovereignty in every state resides in the people of the state, and they may alter and change their form of government at their own pleasure. Luther versus Borden, 48 U.S. 112. Okay? So don't come at me and say you're sovereign. I'm the sovereign, bitch. As to immunity, AG's argument about sovereignty and immunity is a lie, along with other deceptions we'll go into. Okay, this is, if you look at this, this is a 16-page statement that I'm going to make to the judge. This deception is also addressed in the Clearfield cases, which we've been over, and Franconia case in your own Governmental Immunity Act, entered by me, showing immunity is lost due to any contractual obligations. You know what? Let's go to that right now. Okay, I know these are terrible pictures. You'll notice this right here, man. I've got everything in a notebook, and I've got everything highlighted, and I've got exhibits, and I've got scribbly scratches, and this is just crazy. But anyway, this is the Utah Governmental Immunity Act, okay? And it says, Part 1, A governmental entity and its employees retain immunity unless that immunity has been expressly waived in this chapter. Okay? Now, what you do is you go to page 6, part 3. Okay? Part 3, waivers of immunity. Immunity from suit of each governmental entity is waived as to, oh, look at this, any contractual obligation, and as to any action brought to recover or obtain possession of or quiet title to real or personal property. And here's another one. When the governmental entities has taken or damaged private property for public use. Okay? So you waived it, dude. Okay? Don't tell me, whoops, wrong one. Don't tell me, you got immunity. You don't. Because you sent a document to me and you signed it. And you had a representative of your agency sign that document, which means that is an offer, and I accepted your offer upon proof of claim. Okay, so back to immunity. They're not immune, okay? Here's another quote. Where any state proceeds against a private individual in a judicial forum, it is well settled that the state, county, municipal waives any immunity to counters, cross-claims, or complaints. Ludenbach versus the Thekla. Neither the state or federal government have any legal authority to collect money not owed to them on behalf of one citizen to the detriment of another. What? What is child support? That's exactly what child support is. That's Litters versus Lund. Neither the state nor the federal government have any legal authority to collect money not owed to them on behalf of one citizen to the detriment of another. On the contrary, both the state and the federal government do have an obligation and a duty to treat all citizens uniformly across all classes. Well, hang on just a minute. So you go in and they make her an obligee and you an obligor. They make her an custodial parent, right? They make you a debtor. They make you a non-custodial parent. They label you with these public statutory statuses, and they're treating you differently. Okay? And then I went into statute of limitations, and it doesn't matter because we're not talking about the divorce. We're talking about the administrative process, and the statute of limitations is 3 years, and I filed the lawsuit directly right after I did my administrative process. So statute of limitations doesn't matter anyway. Jurisdiction of the court can be challenged at any time of the proceeding. Oh, look at this. And also may be challenged after conviction and execution of judgment. U.S. versus Anderson. Look at that. So the law requires proof of jurisdiction to appear on the record of the administrative agency in all administrative proceedings. By the way, divorce is administrative, marriage is administrative, and family law is administrative. Okay? So you want to go in there and challenge jurisdiction? You could. Okay? There's a bunch of... Okay? And in my case, again, none of the Rule 4 service of process wasn't followed, so I'm going to bring it up too. So anyway, this is more stuff. Okay, and then lastly, persons. All you got to do is look up person. Person in general usage is a human being. By statute, however, the term can include firms, organizations, partnerships, because they always say, oh, we're not a person defined in 1983, 42 U.S.C. 1983. That's deprivation of rights. A corporation is a person for purposes of the constitutional guarantees of equal protection of the law and due process. And persons are defined in Black's Law and in 26, that's the Internal Revenue Code. 7701 is a trust, estate, individual, corporation, LLC, company, entity. You look up individual, it says entity. You look up entity, it says corporation. So a person is a corporate body. Okay? Now, I talk about the divorce a little bit. Okay? And So, yeah. Oh, and by the way, the Social Security number attached to your capitalized version of your Christian name, according to the Federal Code of Federal Regulations, 20 subsection 422103D, it says on the back of the Social Security card, too, it states very clearly that this card is property of the Social Security Administration and must be forfeited upon it. So it's not me, and it's not my number. Okay? Once again, it's more fraud and deception by trying to contract with a child or a child's mother. Anyway, that's 20 minutes. We got lots of stuff to go through. This is what I'm going to order. Okay? By virtue of the allegations stated and pleaded, plaintiff demands judgment against the defendant and prays for relief as follows. So here's my claim for relief. For an order granting summary judgment of administrative process in this bill in equity. I want an order granting the plaintiff relief of compensatory damages plus any other damages the court might find just. For an order ordering ORS to cease and desist and close the case number. For an order ordering a senior agent to adjust the accounting to 0 and send confirmation to me of case closure. For an order for ORS to contact risk management and start the process of approving and distributing my claim within 30 days. I want an order to order the AG's office to put my name on a do not detain list and contact other agencies to do the same. I want an order ordering ORS and all other agencies of this state to remove my name from your system, your paperwork, your files, and leave me the fuck alone. For an order for this court clerk to contact the other clerk of Tooele Court and update the divorce to vacated, adjusted, dismissed, closed, void, set aside. I don't care what word you use. Okay, adjust it and send Mr. Mumi a copy of the update for his records. Plaintiff's representative moves this court for summary judgment, and based on the evidence, summary judgment is appropriate. Okay, guys, we'll see you. Peace.